Companies Act, Section 209, Powers relating to search and seizure. Section 209 of the Companies Act, 2013 confers authority upon the Registrar of Companies or an inspector to conduct a search and seizure operation under specific circumstances. This provision ensures that critical records and documents of a company are not tampered with, destroyed, or concealed, especially when there is suspicion of fraud or misconduct. It incorporates safeguards such as the need for prior judicial approval and outlines procedures aligned with criminal procedural law. 1. Authority to conduct search and seizure based on reasonable grounds. The registrar or an inspector may initiate a search and seizure action if they possess credible information, or such belief arises from other sources, leading them to reasonably suspect that the books of account, records, and other papers of the company, or documents relating to the key managerial personnel, KMP, any director, auditor, or company secretary in practice, where a company secretary has not been appointed, are at risk of being destroyed, mutilated, altered, falsified, or concealed secreted. This belief must be reasonable and based on material information, and it cannot be arbitrary. 2. Requirement of prior judicial approval. Before taking any action to search and seize, the registrar or inspector is required by law to obtain an order from the special court designated under the Companies Act. This ensures that due process is followed, and checks and balances are in place to prevent misuse of search powers. Once the order is granted, the registrar or inspector is empowered to proceed with the search and seizure operation. 3. Execution of search and seizure operation. Pursuant to the court order, the registrar or inspector may a. Enter and search. Enter, with such assistance or personnel as may be necessary, the places where the books, papers, or relevant records are suspected to be kept. B. Seize records. Seize those books and papers that are considered necessary in the context of the investigation or inquiry. However, the company must be permitted to take copies or extracts from those seized documents, at its own expense, before the seizure is finalized. This provision balances the enforcement need with the rights of the company to retain access to its own documents. 4. Return of seized documents and extension of retention period. The law mandates that the seized books and papers must be returned to the company within 180 days from the date of seizure. However, if there is a genuine need for continued retention, the registrar or inspector may extend the period by another 180 days through a written order. Additional measures prior to return. Before returning the seized material, the registrar or inspector is permitted to take copies or extracts from the documents, place identification marks on the documents or on any part of them, or deal with them in any other manner that is considered necessary for preserving evidence or ensuring document traceability. 5. Application of criminal procedural law. To ensure that the process of search and seizure is conducted in a fair, legal, and structured manner, the law provides that the relevant provisions of the Code of Criminal Procedure, 1973, CRPC, that pertain to searches and seizures shall apply mutatis mutandis, that is, with necessary modifications suited to the context of corporate regulation. This alignment with the CRPC gives the search and seizure process under the Companies Act the same procedural sanctity and protections as those under criminal law, including the rights of the parties being searched. For more details, contact us.